guys, good morning all of you. And in last class we were discussing about characteristics of company, and today we will discuss about corporate veil and how to lifting of corporate veil. D. Nikita. So here is new topic after the characteristics of company, lifting or piracy of corporate veil. Firstly, we have to know about what is corporate wealth and or a piracy of corporate wealth. In the last class, we were discussed about a separate legal entity concept or characteristics of company, where we were study about company and their members are both are different and both have different rights and duties and liabilities, etc. Here is a lifting of corporate wealth, which means when a company or a member both are doing their work, and in the case of when company on the behalf of company person doing a fraud or a malpractices for their personal benefit, and at the time of petition or at the time of accountability, uh, they they were said about like they are not responsible for that fraud. Company is responsible for that, and at that time, according to law, and according to law or as per the Companies Act 2013, this is the time where we will mandatory to lifting the corporate well, and after the lifting of corporate well, showing that a company or a member both are different entities, although both are different and both have different duties, liabilities and powers. So this is a brief of corporate will, lifting of corporate will. So here is some members of some time indulgent on a fraudulent activities other their integrity, dishonesty let them take benefit of corporate personality. Yes, of course. Yeah, that earlier I said it. The members were doing their work and for the personal benefit, but at the time of fraud or when they are accountable for that, they were denied for that particular work, and they were said about they are not responsible for that. They or this is a scenario or this is a situation are happened or that is a work totally belongs to a company. This is a, not their personal benefit at that time. Court or a tribunal lifting the corporate well and showing the actual result or actual a person who is behind that a particular fraud or a malpractices. In this case, there is ignorance of a corporate will concept and lifting a piracy of corporate will. Look at the person behind the company who is responsible for that. Effect of corporate will. Company itself is liable to this act and it is a member, director, employee, shareholder are liable, not liable for the act of the company. Yes, for an example, when any work related to the company, so company is liable for that, not a member, shareholder, or a director. So there is a two category: doctrine of lifting the corporate well or statutory provision according to the Companies Act. So shall we discuss? Statutory provisions here is member falling below statutory minimum. Uh, we knowing about that minimum criteria of the members of the company in the case of private or a public limited. In case of a public limited, minimum criteria of member is 7 members of the company, and after the 7 member they are eligible for started a company. But on the another side, in a private company, there are minimum 2 members are required for any company for their incorporation and to start a company operations. So if in the situation there is a below this criteria and company is running after 6 months, so person is liable to pay a liability or a payment of all debt of the company during that time, may be severely sued. Therefore it means when we not fulfill the company criteria, minimum member of the company, first characteristics of the company, or we will knowing about that minimum criteria of how we started a company. Minimum criteria is how much members are required for any company to start it. If they are not fulfill that criteria, so after the 6 months they are liable to pay the debt of the company on a contract during that time. Mispresentation in prospectus. As we know about prospectus is a type of a book that was showing the about a company ki like which is a company, what is the name, how it will be benefit to their shareholder, how it will be benefit to their client, customer, and for their societies, etc. And we were also believed to that book or a prospectus, all the information that are contained or that they were showing all are true and fair. If there is any word or any information that is not correct, or we can say incorrect, or and in actual means, or when his actual results is arising, or when we were discussed about and we were analyzing it, and then we analyze or realize that is not according to their prospect at that time, any mispresentation in the prospect, so they, in the case of default, because of they were not showing actual and true picture of the company, so they were liable to pay a penalty of rupees at least 10 lakh or 1% of the turnover of the company, whichever is lower. 6 months, or also liable to 6 months of imprisonment to 10 years. Amount could be extended to 3 times. That is a penalty in the case of mispresentation. Failure to return application money, section 39 and a SEBI guideline. Here is when we call a, for an example, company issue a share of rupees 10 each, and they were call up a allotment or application money plus first call a whole amount of rupees 8, and after the received that amount within a 30 days of the date of issue. This as the rule. Uh, in a 2070s, the money should be repaid within a 15 days of a clause of issue of the amount is not repaid. The director will be jointly severally liable to pay money with interest. So here is a criteria how that much amount you receive within the 30 days, that will be uh, in the case of a public issue, minimum amount not received. Here is a case when we when we started a subscription or issue a shares. So there is a criteria to minimum subscription we will receive. After that, we will uh, allot shares to their members or to their shareholder. In the case of where they were not receiving the particular subscription amount, so that much amount they were received within the 30s, they are liable to pay to their shareholders within a 30 days and repaid within 15 days of the close of the issue. So before going to close of the issue, there is a mandatory to repay the amount within 15 days. So if they are not fulfill that criteria, fails to do so, at that time they are liable to pay amount, such amount plus interest at the rate of 15%. Holding and subsidiary company, section 129. Company holding company holding company a company when they were hold more than 50% of shares, and separate legal entity, 100% subsidiary, creator and controller. And sometimes a subsidiary company lost their separate legal entity concept in a few cases. So there we were discussed, and shall we continue? There is a point 1. Section 129 subsection 3 contain provision designated provision given better information of confidential position of group and creator public shareholder. The court may be a fact of a case refused to grant subsidiary company independent status. So subsidiary company is a branch of a holding company. As we know, subsidiary company is a helping nature of the holding company. For an example, DAHN Food Distribution Limited, we Zoom, Hamlet's London Boring Council prevail that attain then recover composition, allowed to recover composition when the parent's company was wholly subsidiary or which a subsidiary was carrying in the business was required. Sometimes here is a case when a subsidiary company playing a role as in a holding company, holding company playing a role as in a subsidiary. So at that time, the concept of separate legal entity will be lost in the case subsidiary company. For the facility to task of an inspector appointed and the investigation of ownership under section 216 to find out the entry of the people. So as we were discussed about, sometime they were playing each other roles. At that time they were lost their separate legal entity concept. Director with unlimited liabilities, liable to promoter for pre-incorporation control. So promoter are liable for a company when before they started or before their incorporation, because they were doing work on the behalf of the company. Director are personally liable for all acts which are ultra virus of the company. Ultra virus means beyond the object, that were a director doing a work for the company, that is a ultra-virus. Incorporation does not cut off of a personal liability of the circumstances. So is incorporation not a cut off person? So incorporation, yeah, there is a not personal liability of the of in all the circumstances. Liability under the statutory. So in the next class, I hope this video you will be helpful to understand the corporate lifting the corporate wealth concept, and in the next class we will doing under judicial interpretation. So bye bye guys. If you dislike the video, please hit the bell icon for never miss an update, and if you have any query you can ask on in a comment section, and please like video and subscribe and hit the bell icon. Bye bye, meet you soon.